Friends, how are you? Today I am going to tell you about the topic equity and trust. In the law of equity, we are going to learn about the definition of equity and trust and how a trust is created. So, first of all, we see what is equity and trust laws. Equity can be defined as of equity, fair, even. Number one, the separate body of law developed in the Court of Chancery, which supplements, corrects, and controls the rules of common law. Number two, a right recognized by a court of equity. So next we see trust or equity, a device by which one person holds property for the benefit of another person. A trust imposes a personal equitable obligation upon a person trustee to deal with property for the benefit of another person or class of persons beneficiary or for the advancement of certain purposes, private or charitable. There must be sufficient certainty of intention, object, and subject matter. The modern trust arose from the medieval use, obtaining its nature from the simultaneous holding of equitable or beneficial and legal interests in property. There are said to be three necessary elements of a trust: a trustee, the trust fund, or trust property, and a beneficiary or object, particularly if the trust is for a charitable purpose. Creation of trust. A trust is an obligation which binds a person or persons to deal with property for the benefit of beneficiaries or for a charitable purpose in accordance with the terms of the trust. Chatkati Kachi advocates. A trust can come into existence in any manner by an instrument in writing, including a will, by a unilateral declaration, by operation of law, and also by oral declaration. However, when a trust is created orally, the law requires that there is sufficient evidence of the settler's intention to create a trust. In the absence of unequivocal evidence of this intention, the law will presume that the person intended mandate a deposit and not the creation to a trust. Dr. Matthew Bianchi. A valid declaration of a trust over personal property will not require any formality, provided it can be demonstrated that the settler intended to create an immediate trust over the property in relation to property to be made subject to a trust on death, in relation to trusts of land, and in relation to certain other property. There will be statutory formalities to be satisfied before a valid trust will be created. Hudson 2007, page 207. Specifically, in the case of unit trusts and inter vivos trusts, these cannot be created by an oral declaration. Both of them are generally created by a written instrument. A unilateral declaration refers to a declaration made in writing stating who is the trustee, the terms of the trust, and information on the beneficiaries. One of the key distinctions that can be made in creating a trust is that between inter vivos or living trust and testamentary trust. A living trust is created during the lifetime of the settler and comes into effect with this period. On the other hand, a testamentary trust is a trust created by will which comes into effect only upon the settler's death. These two may have significant differences in the formalities implied for creating and changing the trusts as well as the costs involved. There are also differences that may be significant in certain circumstances depending upon the specific objectives that one is trying to achieve. There are a number of reasons why a trust may be created. These are commonly used by high net worth individuals to plan their financial affairs and provide for other individuals, including future generations. Hence, trusts play a major role in the process of asset holding, asset protection, and succession planning. Monica Gallia, 2010. Besides these purposes, a person may opt for trusts as part of their tax planning and management, business continuation, confidentiality, and to preserve family wealth, especially when children are spendthrift or incapable of managing wealth. So, thank for watching my video. See you in next video.